in the case of the Matthews. Now, I can't get into specifics on that because I currently still do represent Danielle Matthews. They were charged with a written felony complaint. They both elected to testify at the process of the grand jury. We went in, testified, and they were not charged. So basically, while I can't get into the context of the charges were, the grand jury saw fit to not charge them with any crime based upon the evidence the district attorney presented. Most people don't know about or understand. A grand jury proceeding is a secret proceeding that the district attorney convenes, and they don't vote guilt or innocence. They vote, can you charge a person with a crime? And if so, what crime? When somebody's charged by way of a felony complaint, you can elect to go to that proceeding and testify on your own behalf. You have to waive immunity, meaning you understand that you're giving up your right against self-incrimination because you're there to potentially be charged with a crime. If the process is done and at the end, 12 people out of the 26 that are there. To hold a grand jury, there's got to be 26 present. You have to have 16 seated to present the case. You need 12 of those 16 to raise their hand and say, yes, you can charge this person with a crime. If 12 of those people say that, they then control what crimes can be charged. The district attorney instructs them on the law and the crimes that they want them to consider, but a grand jury is allowed to consider any other charges it wants. If they charge somebody, then it's a formal charge. You go to an arraignment, discovery process to potentially to a trial. If you're what's called no bill, if you're not charged, the case is done. Double jeopardy attaches in most times. They can never try to recharge you with a separate body. They can only do that in one specific instance most times. That's if there's newly discovered evidence that there was no way of knowing about it at the time of the first presentment. If that's the case, then they can rebring it with that evidence and afford you all the same. Only time it can ever be brought back, if ever, and there's specific rules that are very detailed with that, is if there's newly discovered evidence that wasn't available at the time of that presentment. It would take a large piece of evidence that was uncovered with no way of knowing. And that's not specific to the case at hand with the Matthews, that's specific to any case.